Good evening, everyone. My name is Jennifer Olmstead. I am the Senior Director of Governance and Operations here at the San Diego County Medical Society. In partnership with the Doctors Company, we'd like to welcome you to our latest webinar entitled Best Practices Documenting Disruptive Patient Behavior. Our speakers tonight will be Kathleen Stillwell. She is the Senior Patient Safety Risk Manager with the Doctors Company, and Richard Cahill, who is the Vice President and Associate General Counsel with the Doctors Company. Now, before I hand things over to Kathleen, I just want to remind everyone that tonight's webinar has been approved for 1.5 continuing education credits. I am going to type the link to claim credit in the chat box. Kathleen will also be displaying a slide, which she just pulled up, that has a QR code that you can scan from your phone to apply for the CME credit as well. We have reserved time at the end of this program for Q&A. So if you do have any questions as we move through the presentation, please feel free to type them in the Q&A box, and we'll get to them once Kathleen and Rich have finished. And now I would like to introduce Kathleen.
Thank you, Jen. Welcome. Thank you for joining us this evening. We know you've worked today, you're tired, and appreciate that you have an interest in this topic, which we think is a critical time because, as you're going to hear tonight, the disruptive patient behavior has escalated tremendously during COVID. We do have to disclose that we have no conflict of interest, neither Rich nor I, and you will get a credit for 1.5 hours. This program is also approved by the American Dental Association as well as for physicians. Tonight, we're going to look at recognizing 3 characteristics of challenging and disruptive patients, understand the importance of documenting disruptive patient behavior on the phone and in the office. And this is primarily your staff that do this, and develop strategies to help reduce your risk for complaints and grievances to the health plan and medical board, because that has highly escalated due to the many unhappy, disruptive, and inappropriate patients who retaliate and make complaints as a grievance to the health plan and to the medical board. And then we're going to talk about also some information that is included about effectively communicating across patient cultures. So this polling question, I'm not doing a poll, but we have done it as a live poll. Has there been an increase of disruptive patient behavior in your practice during COVID? And when we've done this live, 100% of the responses are yes on the phone and yes in person in the medical office. I like to start with a thought from a leader and someone who's overcome a lot. Sir Winston Churchill said, "We make a living by what we get, but we make a life by what we give." And we at the Doctors Company salute you all for what you have given, not just in your career, but specifically during this COVID pandemic, over 2.5 years, and you're still out there on the front lines, giving every day, regardless of the patient's behavior and staff shortages and challenges, you still show up. Challenging and disruptive patients are a problem. You know, Rich and I don't put these programs on to read you every slide. You will have access to a copy of the slides, and also the San Diego County Medical Society is recording this, and it will be available on their website. But the big thing that I want to point out is that disruptive patients can adversely affect your business. It affects your patient experience scores. It could be a compromise in quality of care if patients aren't listening and they tune you out, or they're not following up. They become often non-compliant patients, and certainly a frustration for staff and for the physicians. Who is the disruptive patient? Well, here's a whole list. But what I want to say, what I see most is the second to the last bullet. Nice one day and bully the next day, because maybe they had a bad day. Their life isn't going well and they act it out, they play it out. Also, what we find is that typically even inappropriate disruptive patients are rude to the staff but nice to the physician. They put you on a pedestal. They don't want to misbehave in front of you, but they have no concern about firing on your receptionist on a phone call or coming in at the front desk making inappropriate comments that can be overheard by people in the lobby. And then sometimes the person in the lobby will speak up and say, hey, that isn't nice. Don't talk to her that way, or don't talk to him that way. And then they turn and fire and unload something nasty on the patient in the lobby. This happens. I've had hundreds and hundreds of these calls. And then what are you going to do? So we're going to talk about that tonight, what you're going to do. Do you recognize the disruptive patient? You might not, because they're not acting out in front of you. Your staff needs to understand and recognize and give you a heads up. But one of the things we know that is most in common is that the challenging patient wants to feel like they're in charge. They want to be the center of the universe on the call, in the office. They often have a limited knowledge of medicine and unrealistic expectations of care. Sometimes there are cultural diversity issues that make it hard for them to understand. They might have a command of written English, but not verbal spoken English, or vice versa. It could be that they have a hearing impairment. They have cognitive disabilities. They might be in pain and they're hurting and they can't hear. They certainly don't like to be ignored. And also, one of the things that we see is consistent, and this is in the research, they often avoid eye contact with people. And sometimes, they are suffering mental health issues. With that in mind, I want to show you this from a study that was published on patients affected by the COVID-19 pandemic. Mental health symptoms have dramatically increased during COVID-19. And this study shows that the mental health crisis has exhausted people. 50% more emotionally exhausted, 50% more irritable, 66% report higher levels of stress since the outbreak, 38% increased insomnia, 32% increased anger. And many people just, it's overflowing and it percolates over, and they spill their stress, they spill their anger, and whomever is in front of them is the target. I do need to remind you that effective January 1, we have a new law that we face, and it requires that all accredited CME programs meet new state standards in California for inclusion of cultural linguistic competence and implicit bias. Not going to go into a lot of detail, but I can't get this approved without including some information about this. So you will hear throughout there could be mention of cultural issues. And of course, implicit bias, that's the attitudes, stereotypes, and feelings, positive or negative, that can affect our understanding and decisions. And also the patients have this. They have a bias coming in. We get patients of every race, ethnicity, gender identity, and sexual orientation, disability. You see this in your practice. You're not discriminating. This isn't about discrimination. It's about remembering that communicating with people with such diverse backgrounds requires attention to understand what's going on with this patient. We have to respect how the cultural diversity impacts patients and staff. And I say that because we have to be mindful of our staff as well. I want to remind you that using a translator, if you have a patient who isn't, especially regardless if they're disruptive or inappropriate, we need to be sure that we're communicating with them. You have AT&T language line available on the phone. You might have staff members, maybe the physician is multilingual. I want to remind you that patient and family are not acceptable for translation. And if you are yourself as a clinician bilingual, and let's say you're going to conduct the visit in Spanish or Chinese, document that you used Chinese during the visit if you did not use English, because when it comes to litigation and something comes up, and I'm going to ask Rich to chime in on this, if the doctor conducted the visit in a language other than English and doesn't document it, and then in a deposition the patient says he spoke English and I don't understand English, and the doctor says, I did not speak English, I spoke Chinese. What happens if it's not documented that he spoke Chinese, Rich?
It therefore becomes an issue during the course of trial or arbitration that there was a serious communication problem. If at the time of trial the patient says, I did not understand what was said, the physician or other healthcare provider can clear that up and simply say, I'm fluent in this other language and it was conducted in this other language. That can readily be corrected, but it avoids any miscommunication at an early stage of the litigation where the attorney will believe what the patient told him or her, but at some later time it can be corrected. So it's better to avoid those misunderstandings early in the litigation, where counsel will, of course, believe his or her client.
Thank you. Also, you always want to have a chaperone for personal, private area body examinations, and a chaperone does not qualify if it's a patient, family member, or a guest, and you want to document you use a chaperone. And I bring this up because the patients who are disruptive and inappropriate, one of the most common things we see them complain to the health plan as a grievance and to the medical board is that something occurred during the exam that shouldn't have. And if it was their family member or friend there, I can guarantee you they will side with the patient and say and agree with what the patient said happened. So you want to be mindful about that. Communication problems are the third leading contributing factor in malpractice claims. And so knowing that, you want to be sure that you understand patients hear you in a visit, but 80% of what they hear is forgotten really before they leave your office building. And there have been studies that show this. 5 minutes after leaving the office, they're intercepted and asked 4 questions about the visit, and they can remember very little. The same questions in the study are presented on a phone call to the patient the next day with their agreement to participate in the survey. And so they only had 20% left, and 24 hours later, they only could recall 50% of that, which means if you take this data and say 24 hours after the visit with your patient, the patient is likely to recall only 10% of what they heard. And by the way, the studies show that patients remember most about a visit, what they heard when they were greeted and what they heard when someone said goodbye to them. So that's important to understand. Press-Ganey studies, your practice may not use Press-Ganey, but I will tell you this is important information. Providers with the highest Press-Ganey scores have the least amount of malpractice lawsuits. Providers with the least satisfied patients had 110% more malpractice lawsuits, and in the middle, they only had 26% more. Comments from medical office staff. I do a lot of medical record review, and I wanted to share with you some things that I have taken out of records that I've reviewed. And this is from office staff that documented these kinds of comments. It said the patient used inappropriate language on the phone, called the doctor or staff member a name, yelled at patients in the waiting room, was mean, said nasty, unkind things to the staff, slammed doors, yelled, and threatened staff. These are all very benign, vanilla comments that will not help you get out of the grievance complaint to the health plan or the complaint to a medical board. So Rich, if I just say used inappropriate language on the phone when really the patient on the phone dropped some very nasty words, including the F-bomb to the receptionist, how is it different when the medical board gets the complaint and the doctor responds with the medical record, because you're going to provide medical records, and they see the documentation where the patient used inappropriate language on the phone?
And you hit the key to it. Most of these things occur weeks or months later. Nobody remembers what was actually said. and the patient or a member of the family will simply deny that anything bad was said and said, well, you know, it was a bad day and I may have gotten loud, or I may have had a tone that was not up to my usual standard. And it'll be dismissed as just simply the individual had a bad day. And when I first started doing professional liability and healthcare litigation in the early 80s, we encouraged people not to put things in the record that might reflect badly on the healthcare providers. But then when it came down to describing these things to a finder of fact, whether a medical board, the Office of Civil Rights of the Department of Justice, an arbitration panel, or otherwise, it wasn't helpful to use benign, very vanilla language. We needed to put the actual words in there so that a health plan or other finder of fact would know exactly what was said. Because years or months later, if you don't know what was actually said, it tends to be swept under the carpet. And so even though we tend not to like to use vulgar words, if you put them in quotes, the person that's writing that is not being accused of actually using those words, but simply relating what the individual said. And if you said this person used the F-bomb in the following way, there's no dispute as to what happened later. And as I'll discuss later in the program, the medical records are almost considered sacrosanct because they are made at or near the time of the event. They're part of the business record, and they're considered an appropriate business record. And not only can a person who wrote those records rely on them as part of testimony, but they can be introduced into evidence and be relied upon by judge, jury, or arbitrators as part of the record. And so they tend to be very reliable and they're very powerful. And so even though we prefer not to put vulgar or obscene language into medical records, or even, you know, secondary records like administrative chart entries, those things are important, and be sure to put those into the record so there's no confusion at a later date. The secondary aspect of that is, let's say an attorney meets with a patient and the patient has those words in the chart. The attorney will be reluctant to take the case because he or she will know that those comments will be introduced into evidence at trial or arbitration or otherwise, and it'll reflect badly on his or her client. These cases are very difficult for plaintiffs to win. And if there's something that reflects badly on a patient plaintiff, it makes it even more difficult, and they tend to be reluctant to take a case in which the patient plaintiff has some personality defect that makes it less likely for the finder of fact to find in their favor.
Thank you, Rich. So the takeaway from this is that you want to be sure that your staff is aware of the appropriate manner in which to document these kinds of comments, because they aren't made to the doctor. They aren't made to the nurse practitioner or the PA. They save them for your staff on the phone and in the office. And so an example would be patient called to schedule an appointment, advised physician not available, suggested Dr. Smith, or the NP or urgent care. Patient raised her voice and said, in quotation marks, "You're a bunch of idiots. I don't want to see anybody. I want to see the doctor. The doctor want to see me." And they say something nasty, and that is captured in quotation marks. Not the whole story, just that the ugliest part of what they said. The next thing I want to show you are ER task notes that I saw in medical records I reviewed, and none of these were your records because there was nobody, it wasn't in San Diego. You know, we last April, open notes became the law in the country. The whole thing is that you can now, patients have the right to go into their EHR and see all of their notes. This does include the task notes. They don't really know how to navigate to them, but they could figure it out. But you can't lock them out of anything. And if they want a copy of the records, or for litigation, when we get a copy of the records, we say we want all the records, including all of the administrative notes. These are notes that I found in administrative notes in different electronic health records. And so this was not all in one record. It was in 4 different records. So the patient could see this if they wanted to go look at it. This patient is a hot mess. You need to dismiss this patient from the practice immediately. This was an MA that wrote this note. So you want to be mindful that MAs, this is outside their jurisdiction to tell you that you need to dismiss a patient. That's not appropriate to put in the record. Patient is ignorant, uses foul language, and stinks up the office. Now, if they just said patient is using foul language, I could live with that. But to say the patient is ignorant and use that adjective and to say the patient stinks up the office, that's inappropriate. And if I was a patient and read that, I would be offended. Is this patient for real? You better kick this patient out of the practice if you want your staff to work here. This was actually written by an office manager in a very upscale office. And I let it lay there. You know, that's inappropriate. Why do you let this patient come back when you know he is a drug seeker and liar? Well, you know, you have a lot of patients that might be drug seekers and liars, but we don't turn people away because you're in the business of healing people and taking care of them. Maybe you don't know that they have a drug habit. Maybe you've tried to refer them out. But just remind your staff not to put inappropriate comments in administrative task notes or in messages to you that have subjective information that would be inappropriate to be in notes. These are notes from patient visits where the note was written by the MA in the exam room. And I put them in here to show you this is actually in the visit note. The MA wrote, patient is rude and a pain with staff. Patient lives with a rotten boyfriend and his idiot dysfunctional family. There's no place for that in a visit note. Patient complained the MD doesn't listen and doesn't know what he's doing. Well, that's throwing the doctor that she works for under the bus. That's inappropriate. Patient complained MD is, and she put this in quotation marks, being rough during physical examination, and when she complained, MD told her to be quiet. Well, I know who the doctor was, and when I showed him this note, he was quite upset. He would be the last person on the world that would tell her to be quiet. But the patient said that. The patient had her own version and view of what happened, which that was not an appropriate note for the MA to say that the patient told me this, because it wasn't true. Patient asked, how can you stand working for this doctor? Again, an inappropriate comment to be put into the record. Consequences of poor medical record documentation. Not only can it cause errors and delays in treatment, civil actions by patients or family. They might bring a lawsuit for something which turns out to be nothing, but then they see something, their attorney sees something in the record and says, wait a minute, you don't really have a claim here, but look over here. They're texting you and emailing you without encryption. That's a HIPAA violation. Let's file a complaint with the Office of Civil Rights for a HIPAA violation. Then they'll get a fine and penalty, and then we go after them for a violation of privacy. And I see this happen over and over again. The big ones are medical board sanctions as a result of medical board complaints where the medical record doesn't have anything to defend the doctor's good care and the good actions taken by the doctor's office. Because in the medical record, if someone calls on the phone, the first thing staff will say to me is, it was a phone call, Kathleen. It wasn't a visit, so I don't have anywhere to document it. I say, yeah, you do. If you're using a manual record, then you put a note in about patient called, the date and time regarding blank, and then you say what happened during the transaction or what if there was something inappropriate. If it's in an EHR, you can put that in an administrative note or in a task note, wherever in your EHR your organization tells you those notes go. So for people to say, I don't have anywhere to put the complaint or the concern, yes, you do. It's in the medical record. The same thing with a health plan grievance. I also want to remind you that patients who are inappropriate and disruptive, one of the things that occurs is that physicians often want to dismiss them from the practice. Well, that's a last result. But if you are dealing with an HMO patient, with an IPA or a managed care network patient, for the health plan will require that they approve the dismissal. And in order to approve it, they will say, show us proof of inappropriate or disruptive behavior. And that's not just one example. They want 3 examples. I call it 3 strikes and you're out. So if you don't get that first strike on the nasty phone call, you missed an opportunity. They call back later in the day and they're nasty again. And then they call back 2 days later and they're nasty again. That's 3 strikes, but they have to have it documented. And if you show that, I haven't had a single health plan that said no if it's documented appropriately that the action of the patient was inappropriate and disruptive. Medical board sanctions I see because people retaliate and they go to the medical board website and click on the splash page. It says file complaint, click here. And they say that the doctor refused to see me, the doctor's staff is rude, or the doctor's MA used discriminatory language with me. They don't have to say what it is. That's all they say. And then you get the letter that says there's been a complaint by, Joe Blow that during a visit of X, your staff, your medical assistants are under the supervision of physicians. So it comes on you. Actually, any of your staff, if there's a complaint about your staff, it comes on you and it becomes a complaint to the medical board. And then the whole thing begins. Now, if you're with the doctor's company under our MediGuard coverage, we assist always with the medical board responses. We assign an attorney, and the attorney prepares the response in conjunction with the physician, and it goes to the medical board on the attorney's letterhead. We don't want you to have any conversation with anybody about it. And we also assist with health plan grievances. And so that's part of your coverage. If you're not with the doctor's company, check with your malpractice carrier, and I'm sure that they do something similar. And this does not count as a claim. It comes as an unallocated event. You can have reputation and brand damage is probably one of the most concerning issues. I do want you to think about who are the red flag patients. These are people who are not adherent with follow-up and recommendations. They're the first ones that disclose that they're not playing fair. They're not playing with the rules that you set. They don't come back. They don't call. They don't follow up. You said get the test, get the meds. They don't do it. They might have an underlying hostility and anger. They might be unreasonable. It's very interesting that some of the very patients who become the most rude and disruptive patients, the staff will tell me, at first, this was like one of my favorite patients because he was so gracious. He would come and bring a box of See's candy and give praise. But then, something changed and they call on the phone, and people feel invisible on the phone. And so it's easier for people feeling invisible to be rude and inappropriate. And rude and inappropriate on the phone in the office must be documented. Patient experience is everything. As I mentioned, studies show that what the patient remembers most is how they were greeted and how you said goodbye to them. In test groups and in focus groups, and I've worked with focus groups, said, what do you remember about your last doctor visit? And typically people say things like, well, I love to go because the young lady or the young man at the front desk is so nice. I always feel welcome. And when I leave, they're always so kind. Well, what do you remember about the doctor visit? Well, the doctor's a great doctor. Told me to do this and that and take meds and come back. But I always feel like the people who greet me and say goodbye to me, pat me on the shoulder, they just feel good about it. And so talk to your staff about how they greet people on the phone and in person and how they say goodbye to the patients. And one of the worst things to greet somebody is to say, how are you today? Well, that's not a good question, is it? But say, hello, Mr. Cahill, it's nice to see you again. Or welcome back. Or we're so happy you're back today. We're on time, or we're running a few minutes behind. It might be about 15 minutes more of a wait. But asking people how they are, they come to the doctor's office because they're sick or getting checked out for something. How we say goodbye isn't just bye, see you later. How about something that's more genuine and authentic? It was, thank you for coming in today. You hear that? Thank you for coming in today. We look forward to seeing you next time. With this, I'm going to now turn it over to our legal eagle, Mr. Cahill, to talk to us about legal issues related to your documentation. Rich?
Thank you, Kathleen. Good evening, everyone. My name is Rich Cahill. I'm Vice President and Associate General Counsel with the Doctors Company. I've spent nearly 40 years of my career working with healthcare providers since the early 1980s. And what I've noticed, particularly over the last 2.5 years, and that's why this program I think is so very timely and important, is that disruptive patient behavior has been one of the key issues that we've noticed at the Doctors Company that affects practices. And in that regard, I'd like to talk very briefly about what constitutes professional liability claims. This will give us a framework as we talk about other issues as we go through the program. So what does a plaintiff's attorney who represents patients in professional liability claims have to prove? There are 4 separate components. The first, they have to establish that there was a duty. Well, what is a duty? Essentially, that there was a doctor-patient relationship between the practitioner and the individual patient. And in most cases, that's not an issue. You know if someone that's coming to see you as a patient is your patient, and therefore you have a duty to provide care that's consistent with the community standard. In other words, you have to provide care that's consistent with what similarly trained practitioners would do under same or similar circumstances. When I first started doing this work in the early 1980s, there was an additional component that it had to be in the same or similar community, either regional or actually in the same state. Now it's a national standard. So what's done in Los Angeles has to be done in Bakersfield or Porterville or San Francisco or Miami. So it's a national standard. And it has to be based upon what somebody of similar training or background would do. And if that's not provided, that's considered a breach of the community standard. And that's usually established by independent experts. In my experience, and my clients when I was in private practice included Cigna Health Plans, Kaiser Permanente, and Tenet Health Systems, a large hospital chain. We established the defense based upon what community-based physicians would do. Plaintiffs' attorneys frequently would go to the I guess medical centers and try to get physicians who taught universities and would try to establish their expertise through very impressive academic credentials. I found that most jurors would appreciate physicians who were based in the community and knew what was going on. And they would say that this didn't comport with the community standard. The community-based physicians, I thought, had a better feel as to what was going on. And then they would both testify that based upon their education, training, and experience, that it either was or was not within the community standard. The next thing was causation. Is there a link between what was done or not done, something that caused or did not cause something that was a compensable injury? And in California, that has to be established to a reasonable medical probability. A number of years ago, a few states on the East Coast lowered the standard and said, was there a loss of chance for a better result? More recently in Oregon, they adopted that standard so that somebody could prove that not by a reasonable medical probability, but was there a loss of chance for a better result? Fortunately, in California, it's long been established that it's to a reasonable medical probability. And if you're interested, the case is Dumas, D-U-M-A-S, versus Cooney. And so that's very clear that it's to a reasonable medical probability. And finally, damages. They have to establish to a reasonable medical probability that they suffered general damages, pain, suffering, loss of enjoyment of life. And at least currently, that's capped at $250,000 as a result of the Medical Injury Compensation Reform Act. And in states that don't have caps like that, they use what's called the per diem argument. And they'll argue very logically that, ladies and gentlemen of the jury, poor Billy has suffered a life of this particular injury. How much is that worth? And they'll pick a very reasonable amount, $100 a day. Poor Timmy will have this injury for the rest of his life. How much is that worth? $100 a day. and he'll suffer that for 76 years. You multiply $100 a day times 76 years, that becomes a multi-million-dollar general damages claim for loss of enjoyment of life. The second component is economic damages. That's loss of out-of-pocket expenses, loss of any type of economic injury, which could be a loss of any type of out-of-pocket expenses, which could include any type of loss that may be based upon loss of earnings, out-of-pocket expenses for past, present, or future hospital or medical expenses. And so these per diem arguments can result in very substantial economic damages. So I think that those are the components that plaintiffs have to prove in malpractice cases in California. So in my experience over the last 38 years, who do I find that reads the documentation? Well, early on, patients and families tended not to read the medical records because they were fairly difficult to get to. But as Kathleen mentioned, there was a statute that was passed in 2016 and that went into effect in April of 2021 called the Cures Act. It's also known as Open Notes. Last summer, Kathleen and I published a series of 4 articles that talks about Open Notes, what it is, what it applies to, and how patients are able to now access their notes. Have we found it to be a major issue? Well, a lot of patients are familiar with it, but in our experience, it tends to be that patients are still not accessing Open Notes, but they are, and they have to some degree become more sophisticated. So they do on occasion read their notes. So you do have to be very careful as to what you put in those notes to make sure that they do see and they have an opportunity to review those. And I encourage you at some point over the course of the next weeks or months to look at those articles so you have a better understanding as to what the Cures Act entails. Also, attorneys read notes for various reasons. One, if they are considering taking a professional liability case, they need to know what's in those records to find out whether or not the case may have some ability for them to win. We win somewhere between 75 and 85% of the cases on behalf of the defense. These cases are very expensive to prosecute, and if they only win somewhere between 15 and 20% of the cases, and they're very expensive, they don't want to take cases in which their likelihood of prevailing is very small. Also, independent experts read these to determine whether or not, if they're for the plaintiff, they can support the plaintiff's claim, or similarly, if they've been retained by the defense, whether they're able to support the care that was rendered by the healthcare providers. Also, auditors or third-party payers, whether or not the care that was rendered was medically necessary, the care was actually delivered, or the appropriate coding charges were appropriate. Juries will frequently look at the medical records. Jury trials today are an electronic courtroom. The records are put up on various monitors around the courtroom, also before the jury, and juries have an opportunity to take the records into the jury room during deliberations. So a great number of different categories of individuals will look at these records, and there's a lot of reasons why they might do so. It is a legal document, and as I indicated earlier on, they're made at or near the time of the event when there's no reason for anyone to embellish, so they're considered inherently reliable. It supports the continuity of patient care, so it's relied upon from one healthcare provider to another. It's also used as rebuttal by healthcare providers in the event of a complaint to a state medical board. Ordinarily, and it's very easy for patients to make complaints to medical boards, the first thing that will happen is the medical board will ask a provider for a copy of the records. Do they need to get a subpoena? No. Do they need to get an authorization by the patient? No, because under HIPAA and the California Confidentiality of Medical Information Act, as a government oversight agency, all they have to do is make a request to the physician, hospital, or other medical provider to get a copy of the records, and they must be provided. They look at those and make a determination as to whether the next step, in other words, asking the provider for a statement as to what was done and why, In the vast majority of cases, a request for the medical records ends the inquiry. Also, it's the primary witness as to whether the standard of care was delivered, whether it's an inquiry before the medical board or a professional liability case. Also, it's critical in investigations by CMS or by the Attorney General, also by whether or not a third-party payer is going to authorize payment. The most cited reason for non-payment by third-party payers is there was some question as to, number one, whether or not there was medical necessity. Secondly, whether or not the care was actually delivered. If there's a question as to whether it was actually provided, there will be non-payment. And a large part of my practice, when I was in private practice for many years, I defended providers and also did work on behalf of third-party payers, because if there was a question as to whether the care was actually delivered, there would be a denial of care pending an audit. And finally, whether or not the amount and the billing code that was used was appropriate given what the medical records would say. So, as indicated in the next slide, it's a communication tool. What was done by whom and when? What was the response to treatment? Frequently, we see in professional liability cases, what were the aftercare instructions? Was it clear to the patient and the patient's family as to what the patient should be watching for following discharge, either from the hospital, the emergency department, or the urgent care? Also in litigation, the plaintiff's attorney wants to make sure that the individual was properly advised so that the patient or the patient's family could be on the proper lookout and make sure that he or she knew what needed to be done. And as this next slide indicates, the medical record is your silent witness, because frequently these cases are brought anywhere from 1 to 3 years after the incident in question occurred, based upon the statute of limitations. And therefore, you've seen hundreds of patients in the meantime. Most likely, you're not going to remember what happened. Maybe looking at the records might refresh your recollection, but most likely you will have to rely on what the record said. And the record is an independent basis that can be utilized in court as an independent piece of information on which the jury can rely and independent experts can rely to determine whether or not the standard of care was met. Also used in rebuttal to complaints to the state medical board, often independent of whether or not a request was made to the provider to explain what happened. And of course, it's the primary witness in a malpractice claim, because the independent experts were not present when the care was rendered. They have to rely on the medical records and the deposition transcripts by the individual practitioners who were involved in the claim. Metadata. We're all familiar with metadata. It's the electronic footprint. And both sides in a malpractice case, after they get a copy of the medical records, they ask for the electronic medical records. And most of the lawyers that are involved in litigation, the vast majority of us, tended to be history majors or some other social science, such as political science. We don't have a scientific background, but we can hire people who do have a scientific background, and they look at the metadata and they're able to determine every stroke that was entered into the record, and that can destroy the integrity of the medical record if something was changed. They know who was in the record, for how long, and by whom. That occurred at Cedars a number of years ago when somebody entered the medical record of one of the Kardashians following the birth of one of their children, where people were entering the record just out of curiosity to see what the medical record looked like. And that resulted in investigation by the administration and resulted in some pretty serious fines and penalties. They can determine the password, the time and date of every keystroke. It cannot be erased. It cannot ever be erased, and it will be produced in a malpractice claim or other litigation. So it's important to make sure that you do not ever go back in and try to change things. And why is documentation so important? It's considered reliable. It's timely. It's made at or near the time of the event. It's objective. It tends to be chronological. It's concise. It's complete, and it's considered accurate. So, what is informed consent and informed refusal? Well, informed consent was first articulated in a state case in the city of New York approximately 100 years ago. And it was a very well-written case and became the standard. And now we have refusal to consent, where people, for various reasons, have decided they exercise their right not to undergo care or treatment. And as long as that's properly documented, and it's only become in the last few years where the refusal to consent to treatment has been accepted by the courts. And I recently wrote an article on that, and I encourage you, if you have an interest in the concept of refusal of consent, to take a look at that, because it's very similar to the concept of consent. We used to have the term AMA. Someone comes into the hospital or into an emergency department and at some point decides they're going to leave without having care. And people would try to insist that the patient sign the AMA. They don't have to sign that. But I encourage you to be sure that somebody signs a document to say that the patient was advised that leaving without getting the appropriate treatment, in other words, that they left without getting treatment, they were advised of the necessity of treatment, the pros and the cons of treatment, and also the consequences of leaving without any treatment. In other words, refusal of care can have certain adverse consequences, so that the record is properly documented. In my experience, if that's in a record, plaintiff's attorneys will talk to a patient or a patient's family in the event that the patient expires, and they see the patient says, oh yes, my husband went to the physician didn't provide adequate consent, and my husband died. But if the attorney sees that the documentation was complete and that the patient left and chose not to get the consent or the treatment, they won't take the case, because that's a pretty overwhelming hurdle to overcome when the patient was advised and chose not to get the treatment. A number of years ago, I had a case where a man was a 40-year, 2-pack-a-day smoker, was coughing up blood. Both parents had died of lung cancer. The patient was refusing to have any testing other than a chest x-ray. As it turned out, it was because he had lost his job and couldn't afford any more sophisticated testing. It was an excellent pulmonary practice, and they worked with the patient, and they were able to get additional, more sophisticated testing through community-based treatment. And they were able to diagnose that the patient didn't in fact have early stage of cancer, and they were able to work with the patient. But the patient essentially early on didn't want to have any type of further testing because he simply couldn't afford it. But they worked very well with the patient, and they were able to document all these various things. But had they just given up, would have been equivocal had the patient simply said, I don't want any further treatment, and they hadn't explored it any further. Kathleen just a moment ago showed you our sample refusal of care form, and I think it's important for you to use that in your own practice to make sure that in the event that somebody refuses to consent to treatment, that you have that available. Most likely the patient won't sign that, but it does two things. One, it makes sure it imposes upon the patient the importance that having or refusing to have treatment is very important. And if it's important enough to present to the patient may well give second thoughts. And if not, at least it's in the record, and should at some later time the patient have an adverse result or expires, when the family goes to the attorney will see that the office did everything that they reasonably could to try to work with the patient. And it's highly unlikely, if that type of documentation is in the chart, the attorney most likely will not take the case. Defensive medicine, yes, but it's a very reasonable thing to have in your practice. So is termination acceptable? Sometimes it's unavoidable. And here are some things to keep in mind. Disruptive behavior, verbal abuse where the patient or family member is rude to the staff or the physician. Keep in mind, you have an obligation to make sure that your staff is not being put upon by people visiting the office, by people coming into the office who maybe are vendors. The patient is violent or threatens violence, and you should have some policy in the office in which you're able to have some person in the back office make a call to 911 so that they can come into the office. The police respond very well. I started my career as a deputy district attorney, and in my experience, the police will respond to a healthcare provider's 911 call to make sure that there is no violence in a physician's office. Some years ago, I was going through LAX early in the morning, and I had a call from a practice in Virginia. I don't know how they happened to get a hold of me just as I was going through at 6 in the morning, and the doctor's office called me a little before 6 California time and said, we have a former patient throwing rocks at the office. And I said, we better call 911. And while I was on the phone, the patient escalated the situation and drove a car through the front office window. Well, at that point, the police arrived, arrested the former patient. The situation had already escalated past the point of safe return, but at least at that point, they were able to remove the patient from the situation, and that was a good thing. But you have to be sure to stop the situation as soon as possible. Non-payment of a bill. Before that happens, it's always, I think, a good idea to have conditions of treatment where patients know up front that refusal to pay a bill is something that on conditions of treatment can be a basis for terminate the patient. Also, you should have an ability to put the patient on a treatment payment of the bill so that they know that they won't be automatically terminated, but some type of a payment plan is useful. If a patient brings a lawsuit or threatens a lawsuit, you need to have something where you consider talking with them about that, perhaps having them see another practitioner in the practice. But clearly, if they're suing the practice, perhaps a solo practitioner, the doctor-patient relationship has clearly broken down, and it may be worthwhile considering whether you can continue treating a patient once the patient has decided that that relationship is no longer viable. Also, what happens if a patient says to a practice, I no longer want to be treated here? I think it's important to be able to put that termination in writing, where you follow up with a letter to the patient and say something along the lines of, this letter will confirm that at the end of your last visit, you advised us that you were terminating your relationship with this practice and that you were no longer going to be coming back for future visits. Enclosed, please find an authorization in which you're requesting that a copy of your records be sent to the following subsequent provider. We will do everything we can to transition your care to another physician of your choice. That makes it clear that the patient is no longer a patient of your practice. You, of course, have to be very careful in that situation, not to do it during an active phase of treatment. Next slide, please. Documenting disruptive patient behavior. As Kathleen indicated, it's very important to make sure you document disruptive patient behavior, whether it's telephone calls, follow up with the patient or family, medication errors. All these things have to be put in the patient chart so that at some later point, there's no misunderstanding as to what happened, by whom, or why. Also, documentation of after-hours calls. If a patient calls after hours, make sure that the next day that you enter that into the patient chart. Because if you don't, and something slips, the patient will remember the call, but if you don't have an entry of it in the chart the next day, frequently plaintiff's attorneys like to say, if it's not documented, it wasn't done. Yes, we can argue, and there's a provision in the California Evidence Code that you do have habit and practice to rely on, but it's better if you do record it to say, yes, I do have a habit and practice, and in fact, the next day I wrote it in the chart. So make sure you do follow up, you put telephone calls in the chart, and make sure you record disruptive patient behavior. Here's what happened, and here's how we dealt with it. And it's also important, I think, on your conditions of treatment at the outset of a doctor-patient relationship, to indicate that one of the reasons for terminating the relationship is repeat disruptive patient behavior. And if it happens, I think it's important not for the physician to interact with the patient, but for the office manager to call the patient into a quiet place outside the hearing of other patients to say, your behavior today was not acceptable. Everybody can have a bad day, but we don't expect a repeat of this in the future. It should be recorded in the chart. If it's serious enough, you may want to send a letter to the patient to say, we understand that you had an unpleasant experience in the office today, consisting of, and then detail it. As you may recall, you signed a conditions of treatment at the outset of your relationship. A repeat of this type of behavior may be grounds for termination of your relationship with this practice. We remind you of your obligation to work with our staff, and we'll remind you of this in the future. Put that in the patient chart. And if it happens a second time and it's not sufficient, in your opinion, to warrant termination, send the prior letter with this to make sure it's properly documented. Because at some point, as Kathleen mentioned, particularly if you have HMO patients, it may well be that the HMO will require you to document this and to have written evidence in the chart before they will permit you to terminate the patient. You don't want to be in a position in your group service agreement to do anything that would jeopardize your relationship based on violating the group service agreement having to do with patient terminations. Next slide, please. Train your staff to document inappropriate behavior, because frequently, as Kathleen said, the physicians or nurse practitioners or other mid-level providers will not actually be privy to this bad behavior. It will be the MAs, it will be the receptionists, it will be persons that put the individuals into the service areas. Make sure that they are able to document this, because they're the ones that at some later date may have to provide the information to the health plan or someone else. Also, do not yourselves, as the physicians, be alone with patients with extreme behavior. If you have someone that's behaving inappropriately, make sure that you have a staff member that's present. Also, and I frequently tell practices this, if you become aware that somebody may be recording a conversation, you do not have to allow that. Under California Penal Code Section 631 et sec, you do not have to allow anybody to record anything in the office. If you decide that you don't want that to happen, all you have to say is, under our policy, under federal and state law, we do not allow anyone to record any conversation under any form of electronic device. And if they continue to do that, walk out of the office and have an office administrator walk in and say, we've asked you to stop recording. You have not done so. Your office visit today is terminated. You will be allowed to reschedule. Do not get involved in a confrontation, and it should not be the physician that's involved in this conversation. If the person continues to do it in subsequent visits, it's at that point that you'll want to do a letter to the patient indicating that they violated office policy by recording the conversation. Aside from rare circumstances, there's no legitimate reason for them to be recording these, and it's in violation of the state penal code for them to do so. Ensure that the staff knows steps to take if a patient becomes threatening or violent. There should be some type of a code where they're able to notify somebody in the back office to call 911 to get law enforcement over to assist you. Also have a security code and a procedure for violent patient or visitors, so that nobody on the staff or anybody in the reception area may be at risk. You shouldn't be in a position where anybody is putting anybody at risk. Kathleen has already covered this. Use quotes to document challenging patient behavior so that at some later date there's no misunderstanding. If it's in quotes, it's going to be clearly understood by judge, jury, all witnesses that that was actually the words that the patient used. And also, should it become civil litigation, the attorney that's being requested to take on the case knows that that's what was actually said, and he or she will be very disinclined to take a case where a patient was behaving in that type of fashion. Also, if it's a third party that's, for example, accompanying a patient, for example, a family member, and a family member is acting in an inappropriate fashion, that needs to be captured in the patient's medical record. If the third party is also a patient, not only should that be captured in the patient's medical record, but it should be captured in that third party's medical record who is bringing the patient in for the visit. I think it's important to tell the patient and or the person that's bringing the patient in, we have a zero policy for inappropriate language and behavior. I want to help you, but I will not be able to assist you if you continue using this disruptive behavior or profanity. You need to be firm about that. My experience is once they calm down, they'll stop. And if they don't, law enforcement needs to be contacted right away. I think we've already covered this frame, but if somebody is being inappropriate, I think it's appropriate on the phone to say, I've got another call, I'll be right back to you. That gives them a few seconds to have a timeout. If you need to give the caller a timeout, give them a realistic time frame when you'll be back in contact with them. If you need to tell them that somebody will call them back, give them a realistic time frame, like we will call you back within 10 minutes or 15 minutes, and then be sure to call them back within that time frame and confirm the callback number that you will be calling them back with to make sure that you do call them back and that you have the correct callback number. As Kathleen indicated earlier, it's important not to use opinions or not to use offensive terminology. Over the years, we've seen people write offensive personal opinion about patients. For example, I've seen things where somebody will write, patient's personal appearance today was disheveled, and he looked like he had not slept in several days and had a foul odor of alcohol about him. That type of comments, particularly now that through open notes and the Cures Act of 2016, patients can access that. Also, attorneys can access that, and you have government agencies whose attorneys are looking for that type of thing, and it just doesn't look good. Complaints will be made with government agencies, with the Office of Civil Rights and so forth. So don't document opinions. Always make sure that you simply put facts in a neutral, non-offensive manner. Put what was said and what was done.
So Rich, before we move on, we need to take a brief pause just to reconnect some technology that we lost. So I apologize to everybody while we're doing this. Just give us one quick second and we will be up and running again.
You see me?
Yes, thank you.
Okay, I have to get the slides back up.
And Kathleen, I think while Jen is doing that, that concludes my portion of the presentation. And so when we resume, it'll be strategies to deal with challenging patients. And I think that resumes your portion of the program.
Right. Thank you, Rich. We had a technology loss. And I'm getting it. I think I have to go back to share. Do you see my slides?
Yes, we do, Kathleen. Thank you. And we'll be starting on slide 44. There you go. That is perfect.
Perfect. Thank you. Strategies to deal with challenging patients. This is sort of a wrap up of things that we've said, but reminders. Be patient. Don't show anger. Do not avoid or ignore the challenging patient. This is also important for you to share with your staff, and you can share these slides with your staff. If you want a training for your staff on documenting disruptive patient behavior, That's a program that we offer and do virtually. It's an hour. There's no cost for that. If you're not with us, then with the doctor's company, ask your carrier if they'll do something for you. But using your best-in-class communication skills, that's what we really want staff to do, to always treat someone how we want to be treated, respecting the patient's time. I think when I do training with staff, I say one of the things that you'll hear yourself more often than not saying to a patient is, I'm sorry. I'm sorry the visit isn't going well for you today. I'm sorry you seem unhappy today. I'm sorry that we're delayed. And then people will say, what are you sorry? It's not your fault. I know, but I feel bad and I'm sorry that it's not going as well as we expected it would. And so using I'm sorry is really valuable for your staff to understand. Patients get it when they say I'm sorry. And managing patient expectations is important. Rich talked about setting boundaries. I want us to talk about sending a warning letter, because a warning letter, I want to show you an example of a warning letter. And this is to the patient. Dear patient name, on date, you had an appointment in our office. On your way out of the office that day, you stopped at the front desk to loudly complain you were unhappy with our staff and your wait time. During your date, this is a different date, office visit, you were disruptive at the front desk and verbalized how unhappy you were with our new procedure to update your medical record information. After completing the information, you were upset and demanded, in quotation marks, I want my information back. Our efforts to assist you and explain the information process was required were unsuccessful. Now, this is the third date. You called our office. This is all one letter. You called our office multiple times. During one of the calls, you threatened a staff member saying, there will be backlash if you try to dismiss me from the practice. We value and respect our patients and appreciate the opportunity to care for you. Our goal is to provide high quality patient care and a positive experience for all patients. Our practice maintains a zero tolerance, and it would be for whatever it was, disruptive, rude, or inappropriate language on the phone and in the office. This letter shall serve as a warning that any disruptive actions or comments on the phone or in the office in the future will, or you could say may, result in your dismissal from the practice. We will gladly see you at your regularly scheduled appointments. However, physicians and staff are not available for non-emergent, non-scheduled drop-in visits. This patient had kept coming in for drop-ins. We make every effort to keep our practice running on time. There are times that delays might occur. To avoid excessive wait time, it is recommended you consider scheduling your appointment for our first morning appointment or our first appointment after lunch. This is just an example to say how the office took the quotes out of the medical record and put it in the warning letter. This patient was ultimately dismissed because this letter was provided with a copy of the note from each of these dates, and they were able to dismiss this patient. I want to remind you to remind your staff, do not step into the personal space of a disruptive patient. We don't know what's going on in someone's head. At least we provoke someone and have some kind of violent reaction to one of your employees or to another visitor or a guest or a patient in the office, it can be an ugly situation. We've already seen in the news that a church has a shooting, a market has a shooting. We've had shootings and attacks in medical offices. And you must remember that we cannot provoke anyone. And so the right thing to do is get the person who is disruptive out of the general area. And I want to go back to Rich's comment about have a code. A code is a violence code. You can't say somebody call 911 and everyone in the office and in the lobby can hear that. It'd be very disturbing. Instead, you come up with a code in your office, pick a doctor's name that there's no doctor by that name. I'm going to go with Dr. Pink. And if somebody is threatening or abusive to me, and I say, if I'm talking to someone at the front desk and someone comes up, and this has happened, and threatens the receptionist, and the receptionist and says, and I had one where they pulled out a box cutter and said, I want to see Dr. Smith. no, that's not the real name, Dr. Smith right now. And she said, okay, I will see if I can get him, but I believe he's in a meeting with Dr. Pink. Okay, they had a lobby full of people. That was the cue to call 911 and said, would you like to sit down? No, I'm going to stand right here, and said, okay. So, well, can I take you into the office? And they got the manager, and he said, no, I'm standing right here. Shut up. And people in the lobby heard him say, shut up. And somebody made a comment to him and said, that's not very nice. He turned around with the box cutter and said, shut up or I'll use this on you. But he didn't say it that nice. Well, they were in an area where the police response time was less than 5 minutes. And he had his back to the door, and here came through the door 4 police officers. And when they called, they said, we have somebody at our front desk. He's wearing, they described his jacket. And they kept her on the phone with 911. And he said, he's still standing. He won't leave. He's got his back to the door. They said, okay, we're coming in. Have nobody else behind the door. And the office manager went to the lobby and just told everybody, please sit quietly. Everything will be over in a moment. Police came in and they arrested him right there. How are you going to get somebody to signal, call 911, and then you have telegraphed your punch? So think about having a code in your office. Patients want to feel that they're in control, and sometimes you just can't reason with them. You have to say, okay, we'll get that for you. We'll do that. I had a situation where the patient, a man, got into the exam room with the doctor, and he had done our training on dealing with a violent intruder 2 weeks earlier. And he called me and he said, I need to call you, Kathleen. 2 weeks ago, we had that training for our office, and we came up with it. They had a doctor, they used Dr. Green. And he said, somebody came in and everything was fine. And he was a patient that had been there once before. He came in the exam room. The doctor came in and shut the door. The MA was not in the room. And the guy pulled out a gun and he said, I want the drug box. Well, I don't know why people think that there's drugs in doctors' offices, but they do. You might have some samples. And the doctor said, okay, but I have to go get it. Wait here and I'll go get it. He said, no, you're not leaving the room. Call out and tell somebody to bring it. He opened the door and he said, could somebody please go in Dr. Green's office and get the drug box? And somebody came to the outside in the hall and said, Dr. Green's not here. We don't have a key to his office. I'll have to call him. He said, okay, how long will it take? She said, we're calling him now. And she came back and said, he's going to be here in 10 minutes. Well, in less than 10 minutes, there was a knock on the door. And part of the training was when you open the door for the doctor to be behind the door. He opened the door and got behind it. And the SWAT team came in and arrested the guy. And of course, they had bulletproof vests on. But these things really happen. This was in a very upscale, very nice Orange County office. So we have so many unknowns about people that are in our environment today. Own what you document. Again, I want to remind you to identify a translator, identify a chaperone, document the language used for a visit. If not English, we have such a wide variety of physicians that are multilingual now. It's amazing. Rich talked about metadata. I want to remind you, you cannot hide anything. If you put an entry in the record and it's wrong and you backspace it out, it will show. Now, how do you explain that? It was the wrong patient. So changing the EHR may impeach the medical record integrity. So that's why you don't ever want to go in and make a change. The last slide is one of my favorite of the whole program. Comes from the Dalai Lama. Do not let the behavior of others destroy your inner peace. At no time in over 100 years have we had a pandemic like we have been through and we're still in. And I'm getting calls that suggest there's a slight increase in the surge again right now of COVID. People are not as sick and they're not getting hospitalized, but physician offices are short-staffed. And be aware that these challenging times are not ending right now. And thank you for being out there and continuing to serve the people in the communities that you serve. I want to remind you that you can get 1.5 credit hours for CME. You can, if you have a smartphone, put your camera up and hold it up to that QR square, and it will take you, this is number 1. And then you can go over here to this screen. You will put in your first and last name. I can't read that. I can't read it, but your affiliation is just the name of your practice. And then your email address, that is where your certificate will be sent. And then you're going to say check in now. That's a check-in. After the program ends, the evaluation you will go back to this on your phone, and it will say complete evaluation. You do the evaluation. It has, I think, 7 questions. 1 is the lowest score, 5 is the highest. And I hope that you felt that the program brought you some information that was useful. But what I want to remind you is you must scroll to the bottom after you answer all the questions. Scroll all the way to the bottom where it says submit. We have many people who call me and say, I did the evaluation, I never got a certificate. And then I have my assistant go in and look them up, and it's a manual process. It's time consuming. She says they did it, but they didn't hit submit. So you must do the submission check-in. If you have any questions, my phone number, my email address is here. Invite you to call anytime. And what I want to do now is I'm going to end the slideshow, and we're going to see if we have any questions. So let me ask our lovely host, Jen, are there any questions this evening?
There are. And Kathleen, do you want to stop sharing your screen? So there you go. Perfect. All right. We do have a couple questions that have come in. First, one of our viewers, this is regarding an example that was used several slides back. When a patient is disheveled and smells of alcohol, that actually is important clinical information. So how would you like to see that information documented in the patient's chart?
Well, I'm going to make a comment and then let Rich give the legal view. And there are times when that is going to be appropriate. So as long as it is documented, I think that the physician is the one who should document it. The medical assistant may put some documentation in, but it should be objective criteria. Patient disheveled, it can smell alcohol on the patient. If that's not subjective and you smell it, but I think that if they smell alcohol, that the physician should also be documenting that. Rich, what do you want to chime in on that?
Well, I agree with that, and I don't think it's something that should be just, notated lightly by a non-clinician. Something like a patient presented disheveled, maybe even appeared disoriented and had an odor of alcohol. That's fine. To go beyond that, unless it had to do with cognition or something, probably isn't necessary.
I'll give you an example.
For example, just a second. For example, if the patient, fell to the level of being 647 AF, unable to care for himself or others, that might be relevant.
I will give you an example that I found in a medical record review last year. And the doctor wrote, patient looks like a clown today. Her red lipstick is smeared on her lips. Well, was that necessary? I don't think so. I think that was subjective, and to say she looked like a clown, it wasn't describing that she didn't have the ability to put her lipstick on right. So most of the time, I also want to say that a lot of practices get people who are homeless in, and they do have body odor, and they do have dirty clothes, and they do smell. And it's a problem sometimes in the lobby. But these same homeless people, they're Medicare, they're Medi-Cal, they're veterans, and they have benefits that pay you to see them. And one of the things I like to say is when you get a patient like this, it's nice if you have a handout that you can give them, or the MA can give them at the end. They can say, here's a shelter in the area where you can go shower and get some fresh clothes, or here's a resource in the community, because these people, they need health care and they need help. And I know, I do know that people cannot be turned away if they come into your office just because they smell. And so you have to say, if they sit in the lobby and if the person comes in and the receptionist notices that they have a strong odor or there's an issue, you shouldn't have them waiting in the lobby. You should get the manager and say, this person just came in, can we get them in an exam room early, or have them in a waiting area that's not within the lobby where it can be upsetting or distressful to other people. It was a good question.
Couple more questions. Rich, can a physician record a patient visit with a patient who has been inappropriate in the office in the past?
That gets back to what I was saying earlier about Penal Code Section 631. California requires any electronic surveillance to be agreed upon explicitly by all parties to the communication. You'd have to have a sign in the office that says something like, all patient visits will be recorded electronically, both video and audible. You got to be real careful with that.
And then
a lot of offices, I wanted to add something to that. A lot of offices call me about that question, that somebody wants to record, or they come in and they're video recording people in the lobby. That's not allowed. And many offices now post a sign that says no audio or video, no audio recording, video recording, or photography allowed in the office. I have more offices
in accordance with federal and state privacy laws. And not only can patients not do it, but offices can't do it either.
So another question for Rich. In this age of social media, there's a concern that a patient could possibly go on social media, criticize the physician and the practice, as well as their staff. Can they request that a patient sign an agreement that they cannot post anything about the practice on social media?
You could do that, but it's not valid.
Okay. And then Kathleen.
And all it'll probably do is inflame patients, you know, and then they'll do it anyway.
Kathleen, one of the questions, what if I do not have staffing to support a chaperone with every single patient personal exam?
Well, then you're going to do the best you can. And one thing I say is, you know, a chaperone doesn't need to be in the room for the whole visit. And this happens especially in a solo practice. Maybe you have one MA and a receptionist. The receptionist is out and the MA is having to do receptionist and MA. So it's understood. But if you're going to do, for instance, a breast exam, a pelvic exam, a prostate exam, something in what I'm going to call the private regions, I would still say, ask this person to come in and just be in the room for, it's like 3 or 4 minutes, rather than not have anyone. Now, if you have a patient that's been your patient and you're comfortable, and you know, then you have your own instinctive intuition to make a judgment. Is it okay to not have a chaperone here today? I want to tell you something though. We have more claims for violation of sexual misconduct between same-sex patients and physicians than opposite sex. So bear that in mind. And with the 805.5 reporting, if a patient submits a written letter to the practice that the doctor was sexually inappropriate, you are required by law within, isn't it 15 days, Rich, that you have to submit that letter to self-report to the medical board, and there is an investigation. And it is not a pretty experience for a physician. I have seen most all of the instances where this has happened since the law took effect was in summer of 2020. They've most all been vindicated, but the investigation can crawl and take 6 to 18 months or longer. So if you just be mindful of that. I have doctors who say, well, I'm only going to do it if it's opposite sex. And my answer is, or my response is, I would rethink that. We have more complaints with same sex than opposite sex. Rich, do you want to say something about that?
No, you hit it right on the head, and it's mandatory, and there are significant fines if you don't do it.
Thanks, Kathleen. And I know you've covered this in previous webinars, but I think it would be particularly helpful to go over it again for this one. Can you briefly go over the options they would have for translation if the patient's family member cannot translate for the patient?
Well, first of all, the patient's family member is not acceptable for the translation. Let me give you an example where I've had time and time again, the doctor calls and says, the husband or the wife is doing the translation, and my MA's in the room. She didn't tell me she spoke this language, and she had me step out of the room and said, the family member is saying the opposite of everything you're saying. And so you don't know what they're saying. There is an option, AT&T Translation Services on the phone. It's I think 850 languages and 14,000 dialects or 1,400 dialects. There's Google Translate on the phone. There, if you have a staff member who speaks the language, they could translate. Sometimes you are going to end up maybe using someone, but then you want to document. Patient's husband, Joe Stillwell, translated in Korean. You want to document who was the translator, because when these things come up in court years later, nobody remembers anything that happened at that visit. Patients can say whatever they want. I think the good thing, and I'm going to ask Rich to follow up my comment with his own, is that juries love you, doctors. They have trust and confidence in you, and they usually side with you over what a patient says. And I'd like our attorney to weigh in on that.
I agree with that 100%, particularly if it's recorded in the record.
And I know we're coming up on 7:30, but Kathleen, Rich, there's one other question that Dr. Parker brought up that I think is important. What about when a patient has dementia or memory loss, and the doctor doesn't inform the family members about tests that need to be followed up, and there's an adverse outcome? The patient didn't tell the doctor it's okay to discuss their care with the family, but they have cognitive decline.
Well, I'm going to make a comment first about the clinical part of it, and then Rich, let you talk about the legal part. If you have a patient who has cognitive deficit, an important thing for you as the physician is to refer to a neurologist or a psychiatrist for a competency evaluation. Because without that, you as a primary care internal medicine, you don't know, and then you can find out what the results are. You can also say to the patient, I would, right now you don't have anyone, you have an emergency contact, but you have not signed an authorization that we could speak to anyone in your family or someone close to you if we needed to discuss your care with someone else. And we would like to know if there's someone, a family member, a close friend, or a relative, in case we needed to get in touch with someone, so that protects you legally under HIPAA, because otherwise you can't. And an emergency contact is not a HIPAA authorization. And so this is important if you see someone who has cognitive deficit, which sometimes is just off and on. I come for one visit and I'm fine, and the next time I come and you think, what's going on with her? But so getting it evaluated with a referral is important. Looking in the record and say, who can we talk to? We don't have any authority to talk to anyone. And if I'm in my 80s and I have an 89-year-old husband or companion, I wouldn't go for that person. I would look for somebody else. Do you have someone else in your family, Kathleen, that we could talk to? and then you get a HIPAA authorization and they can discuss. Rich, from a legal standpoint, what would you say?
That's a good first step, but then it becomes a more difficult question that just talking to you may not cut it, because you need a power of attorney or a conservator appointed. So in other words, talking to you is fine, but if you don't have a power of attorney or you don't have a conservator appointed, then you're in a difficult situation. And that's why your recommendation of having a psychiatrist or a neurologist do an evaluation is the key next step.
Another thing to bring up is when patients come into your practice and annually, it's important to ask them, do you have an advance directive? Because advance directives today show who they appoint as a conservator. But if you have that, that doesn't mean you can go to that person. That's because you would first have to have them have that evaluation by a neurologist or a psychiatrist. Those are the ones who evaluate competency. And then you could have that evaluation and help the patient to get a guardianship, a conservatorship, or someone that could be a helpful decision maker. Those are really good questions. Anything else?
Well, I think we are coming up on 7:30, so it is probably time for us to end. Thank you, Kathleen and Rich, for yet again another terrific presentation. As always, we appreciate you guys joining us, all the information that you give to us. As a reminder to everybody else, we've put in the chat box how you can claim your CME credit. If anybody has any suggestions for future webinars, we would encourage you to send those potential topics to us via email. You can send them to SDCMS at sdcms.org. And for those of you that are members, thank you so much for your membership. For those of you that are not currently SDCMS members, we would encourage you to go to our website and consider joining us. Thank you so much. Have a great evening, everybody. Good night.
Thank you. Good night. Have a great rest of the week.